Oh, good evening. Good evening and welcome to OCU School of Law. My name is Jim Roth. It's my privilege to serve as the dean here, along with our awesome 467 students, our faculty, and our staff. It's quite a community. Wonderful to see a few familiar faces back there, Larry, Dean Emeritus, Dean Hellman. Thank you for being here. Gay, great to see you as well. I see several of our professors, Art LaFrancois, Andy. Thank you all so much for your time and being here tonight. This is a special moment for us in the calendar at OCU School of Law, in particular because of its long-standing part of our tradition here. We're thrilled to have tonight's speaker, and I'm going to give those honors to Professor Tellman. But I first wanted to tell you a little bit about the Quinlan Lecture Series in case you weren't familiar, as well as welcome the family that's here, and we're grateful for their effort to be here. This is quite a career in talking about Mr. Quinlan, so I want to share this with you. This lecture series was established in 1981 to honor Professor Wayne Quinlan. He was an OCU professor from 1962 to 1981. He earned his law degree in 1948 from the University of Oklahoma and began adjuncting at OCU in 1952. He had an interesting and prestigious career. He was appointed by Harry Truman at the age of 32, if you can believe that, to serve on the 3-member emergency board created by the Railway Labor Act. He also served as a special justice at the Oklahoma Supreme Court in 1966 and 1967 as an arbiter on numerous labor relation cases. The Quinlan Endowment, created in his honor, was supported this lecture series now for over 4 decades. We're honored to be joined by his daughters, Catherine and Megan, who are here with us tonight and have a wonderful tradition of being present every year. Thank you both for that. And sadly, I understand, Megan, with John's passing in December, our hearts go out to you and your family for that. I wanted to share with you that the OCU School of Law family is making a contribution to Farm Africa in his honor, a charity which he advised as a UK-based charity set up in 1985 that works with farmers, pastoralists, and forest communities in Eastern Africa. So on behalf of OCU School of Law, know that we're hugging you both and thinking of him tonight, and we offer that as a gift in his name. We're glad that you're here. We're thrilled that you're here, Doctor. Thank you for your time with us, and Professor Tellman, the honor is yours.
Good afternoon. It's great to see such a full room. I'm going to make this short because you're not here to hear me. So we're thrilled to have Professor Norton with us. She is a University Distinguished Professor and the Roth-Gerber Chair of Constitutional Law at the University of Colorado. She's also been serving as special counsel to the Colorado Attorney General on civil rights. And in that capacity, she's gotten to have the thrill of getting involved into some Supreme Court cases recently, which would be a topic in its own right. She is an authority on freedom of speech generally, on government speech. She has interesting thoughts about negative theory of the First Amendment. Like my colleague, Professor Blitz, she's written a lot about technology and the First Amendment. She has a book from 2019 called Government, Speech, and the Constitution. She's working on her next book, which is about lies and the Constitution. I'd like to offer the title Lies, Damn Lies, and Constitutional Lies. That's free. Today, she's here to talk about when speakers and listening's First Amendment interests collide. I see some of my 1Ls here, so I could advise you. I am confident this is going to be based.
Thank you so much, all of you, for being here. It's such a pleasure and a privilege to join you today. Thank you, Jeremy. Thank you, Dean, for your warm remarks. Thank you, Quinlan family, for traveling so far to join us. It's such an honor to be invited to deliver this lecture, and what a terrific and wonderful recognition of Professor Quinlan's teaching and service and his love of constitutional law and American history. And also to such an honor to join those in the past who delivered this lecture. I took a look at those folks, and that is an amazing group, and I'm very, very happy to be here with you today. So constitutional questions are especially challenging when they force us to make hard choices between important constitutional values. And along these lines, some First Amendment problems are hard because they demand that we choose between speakers' First Amendment interests and listeners' First Amendment interests. So, for example, we have to choose between speakers and listeners when listeners want speakers to reveal information that speakers don't want to disclose. And we have to make these choices when speakers want to lie or shade the truth, when listeners want nothing but honesty and accuracy. And we have to choose between speakers and listeners when listeners want to be left alone, but speakers want to talk to them. Now, attention to listeners' interests, which is the focus of my talk, doesn't always change the First Amendment outcome, but sometimes it makes First Amendment problems easier. Sometimes it makes First Amendment problems harder. And it offers a way for figuring out why hard problems are, in fact, hard. So my plan today is to explain the role of listeners' interests in shaping past Supreme Court decisions, some involving political campaigns, some involving commercial speech. And then I'm going to look ahead to the role that listeners' interests can play, or in my opinion, should play, in some contemporary problems, including a threats case that's currently before the Supreme Court and other problems involving robotic speech or artificial intelligence speech. Now, to think about these First Amendment problems, these collisions between speakers and listeners, I want to start by thinking about the underlying values or purposes of the First Amendment. In other words, why does the Constitution protect speech? Why? What's the point? What's the objective? And it turns out that there's multiple answers to this question. One answer to this question is that speech is a valuable end in and of itself, that speech is intrinsically valuable because it's central to our individual expression, our autonomy, our self-fulfillment. So under this view, speech is fundamental to how we develop and express our own identities. Speech is part of being fully human, such that it's just wrong for the government to interfere with our humanity by restricting our speech unjustifiably. So under this theory of the First Amendment, this answer to the question of why the Constitution protects speech, speech should be protected even if nobody apart from the speaker finds it interesting or valuable, that speech should be protected solely because of its value to the speaker's own sense of individuality, of personhood. So this is the idea that speech is valuable. It's part of who I am, even if nobody else hears me singing in the shower or wants to hear me singing in the shower, or nobody else is going to ever look at my private journal. The idea is that it's part of me that deserves protection. Now, other justifications for protecting speech are more instrumental in nature. In other words, this is the idea that speech is a means to other ends, that speech is valuable in itself because it helps us get to other valuable things. These ends, these objectives include enlightenment and the discovery of truth through the marketplace of ideas. This is the idea that exposure to facts and opinions helps us develop our own ideas and our own opinions. It helps us identify our own conceptions of the best arguments, helps us identify what we think are good and solid ways to think about problems. It helps get us to truth and enlightenment. Now, another possible instrumental argument is that speech is the end to democracy. And this is the idea that a healthy democracy depends on free thought, free expression, dissent. That free speech, like political opinions and political ideas and political dissent, is necessary to open and healthy democracy where people can discuss policy, can discuss candidates, can discuss the government and its performance, including discussing all of those things in sometimes very critical ways. Now, other folks argue that it's important to protect speech as the means to an end of social stability, that speech can be a safety valve. And under this view, if people can complain to each other and if people can complain about each other, then they're less likely to physically attack each other. They're less likely to fight. And some argue that speech helps us develop good character traits, both individually and as a community. And the idea here is that if we're exposed to the fact that other folks have ideas and perspectives that are very different from our own, exposure to the fact that other people have ideas and perspectives that we might find puzzling or challenging or even upsetting, that exposure helps us develop positive character traits like curiosity, independence, and courage. Now, all of these that I've talked about so far are called affirmative theories of the First Amendment, affirmative answers to the question of why the Constitution protects speech by explaining why speech itself might be a good thing. It might be affirmatively valuable. But there's another very different answer to the question of why the Constitution protects speech, what some call a negative approach to the First Amendment. Negative First Amendment theory doesn't focus on whether and when speech is all that great. Instead, the idea is that the government is often dangerous in its capacity to abuse its regulatory power, such that we should figure out when the government is incompetent or biased or self-interested in its regulation of speech, and we should prevent the government from doing that. And again, this is called negative First Amendment theory because it's rooted in a negative value, distrust of the government. The idea that the First Amendment may be more about our fears of our government than about affirmatively celebrating speech. So these are all multiple possible answers to the question of why the Constitution protects speech. And to be sure, they're not mutually exclusive. Courts and commentators often rely on multiple theories rather than insisting on any one to the exclusion of all others. Different folks have different favorites among them, and I urge you to pay attention to your own intuitions, your own favorites among these, your own answer to the question of why the Constitution protects speech as we continue the discussion. Okay, so once we start to think hard about why the Constitution protects speech, we can see that most of those answers, most of those values, purposes of the First Amendment are at least as important to listeners as they are to speakers. In other words, we value protection, we protect expression, at least in part because it provides certain affirmative benefits to listeners, not just speakers. Expression furthers listeners' self-governance. It enlightens listeners by exposing them to the marketplace of ideas. It can inform listeners' choices and the exercise of their autonomy. And even from a negative theory perspective, listeners can suffer along with speakers if the government abuses its regulatory power. Now, often speakers and listeners are on the same page. In other words, often their interests are aligned. This is the case when speakers want to speak and listeners want to listen to them. But that's not always the case. Sometimes we have to choose between speakers and listeners' First Amendment interests. Again, one common example is where speakers would actually prefer to remain silent when listeners want them to disclose certain information. Think, for example, of situations where listeners want government officials to disclose their tax returns, or they might want manufacturers to disclose their products' hazards, when those speakers would prefer not to. Another example is where speakers want to tell lies while listeners want to hear the truth. Maybe I'm trying to sell you my used car, and I'd prefer to exaggerate its strengths while you would prefer me to be scrupulously honest. Or maybe I'm running for office, and I'd prefer to exaggerate my own strengths, maybe my military service or my education or my employment, where again, you as a voter might prefer me to be honest about those things. And again, other conflicts between speakers and listeners involve situations where speakers want to speak, but listeners don't want to hear it. Think of telemarketing. Think of robocalls. So when this happens, when speakers and listeners' interests collide, when we have to make a choice, whose interest should we prefer? I'm going to explore some situations in more detail in a minute. But first, I want to tee up some possible tiebreakers, some possible decision-making principles to consider when we have to choose between speakers and listeners. One, again, is based on negative theory, the view that the primary purpose or a primary purpose of the free speech clause is to protect us from a government that is too often partisan or self-interested or clumsy. So under this view, close cases should always go against the government. So whenever the government regulates, including if the government is regulating speakers to protect listeners, say by requiring speakers to tell the truth or to disclose certain accurate information, a negative theory view suggests we should be suspicious of the government because it's the government. Another possible tiebreaker might take a majoritarian view that privileges the views of the people's elected representatives if they choose to regulate. So under this view, close cases should be resolved in favor of preserving politically accountable actors' choices to regulate in a particular area. And if you don't like the regulation, the idea is you leave it to the people through political means like protest or lobbying or voting. rather than constitutional litigation. You might actually think about this as a different type of negative theory, where it's unelected courts as opposed to elected officials that make us nervous. We prefer to entrust folks that we can vote on with these decisions. And then another possible tiebreaker, another possible decision-making principle would be to prefer listeners in situations where listeners have less information or power than speakers, in certain settings where listeners are not operating in a position of equality, and that this compromises their ability to exercise their First Amendment interests. I'll note that this last one is my own preferred tiebreaker, as we'll see. I think that when we take the sides of listeners in relationships where speakers have more information or power, in my view, we improve the quality of the discourse. Now, there may be other tiebreakers, and I'll be curious to hear your thoughts in the discussion period. But again, the primary objective of my talk is not to persuade you to adopt my decision-making preferences, to adopt my tiebreaker. But instead, my goal is to persuade you that the collisions between speakers and listeners' First Amendment interests are important and complicated problems that deserve our attention and our concern. So the bottom line is, my goal here is that I think we should be on the lookout for these sorts of tensions, these sorts of collisions between speakers and listeners. And that when we see them, we have to recognize we have to ask an additional set of questions that focus not just on speakers, but also on listeners. And that we should search for principled approaches for solving these problems when speakers and listeners' interests collide. And again, as I go through some scenarios, I encourage you to pay attention to your own intuitions. How do you think these problems should be resolved, and why? Now, as we'll see, First Amendment law sometimes permits the government's intervention in environments where speakers and listeners are not operating from equal positions. In other words, in settings where the speakers have more information or power, or both, than listeners. These asymmetries between speakers and listeners not only increase the likelihood of harm to listeners and possibly the severity of harm to listeners, but they also limit the effectiveness of listeners' traditional self-help remedies, avoidance and rebuttal, exit and voice. Here's what I mean by exit and voice. The ability to exit means that the unwilling or the unhappy listener can protect herself from speech that she doesn't like simply by ignoring the speaker or walking away, exiting the conversation if she chooses. And voice means counter speech, the ability of a listener to protect herself from, again, unwelcome speech by speaking right back, by talking back, by resisting, challenging what the speaker is saying. Those are the traditional remedies if you don't like speech that you hear. Leave or talk back. But there are some situations where listeners have less information or power than speakers, where they may not be able to walk away, or they may not be able to talk back. Where might we see this? I'll give you a number of examples. Situations where the speakers generate all the key information themselves. And this is the case of commercial manufacturers and sellers' speech about their own products. They know more than anybody else about their product strengths and also about their product's limitations, maybe even their dangers. Listeners don't have the counter speech. They don't know as much about it as the speakers do. Another example is where speakers have more training or expertise than their listeners. And here an example is doctors' speech or lawyers' speech, their patients and clients. When their patients and clients entrust their doctors or lawyers with confidential information and rely on them for expert advice about life-changing choices. The listeners don't have the same information, and to the extent that they're reliant, they're in a fiduciary relationship, they may not have the same power as the speakers. And still another set of examples involve situations where speakers have physical or economic or legal control of the listeners, like law enforcement officers' speech to folks in their custody, right? Miranda warnings are a listener-centered approach. Other examples sometimes include employers' speech to their workers, where the workers may not be free to walk away from the conversation or to engage in counter speech. So let's take a look at some different speech environments. And I'm going to start with what's often called public discourse. And this includes speech about political issues, political ideas, political dissent, campaign speech. This is the universe of speech central to democracy, often thought to be at the core of the First Amendment. And thus, it's the area of speech that's most rigorously protected from the government's interference by First Amendment law. Now, First Amendment law presumes that public discourse speech occurs in an environment where speakers and listeners are equal, and where speakers and listeners' interests generally align. Under this presumption, more speech is pretty much always better for speakers and listeners. And listeners can protect themselves again by exit, walking away, or voice, counter speech, or rebuttal. They don't need law if we're truly in a situation of equality. And as a matter of negative theory, we might also worry that the government's regulation of speech in public discourse is especially dangerous because the government may be poorly equipped to make these decisions, or the government might be self-interested, might have incentives to regulate in self-interested way. Now, again, those presumptions may not make sense in other settings. Finally, even if we were to agree to prefer listeners in public discourse, and we might not want to, but even if we were to agree to do that, we could still vigorously disagree about what is actually better for listeners, what's best for listeners, what's in listeners' interests. So I want to illustrate these principles by starting with political campaign speech. I'm going to very briefly discuss two holdings from the Supreme Court's Citizens United decision from 2010. This involved two First Amendment challenges to federal law that regulated corporation speech related to political campaigns. The first, more famous part of Citizens United involved a challenge to a federal law that prohibited corporations from buying or making campaign ads that advocated the election or defeat of a specific candidate during a specific window of time, 30 days before a primary, 60 days before a general election. And the challengers, the folks who brought the First Amendment case, were corporations that wanted to engage in this campaign speech by buying or making campaign commercials and ads. They wanted to be campaign speakers, but for this period of time, the federal law did not allow it. In a 5-4 decision, a closely divided court struck down the law, struck down the federal limits on corporations' ability to buy or make their own advertisements in political campaigns. Now, note that everyone on the court at this time, every single justice, both the majority and the dissent, agreed that the primary First Amendment purpose of political speech, perhaps its most important First Amendment purpose, is its great value to listeners, to voters who receive it. Campaign speech delivers information and ideas and opinions to voters that helps inform their own opinions and helps inform their choices about who to support, who to vote for. Where the disagreement occurred is that the court's members, majority and dissent, vigorously disagreed about whether unlimited corporate campaign speech is valuable to listeners or not. The majority, on one hand, found that corporate political speech is always valuable to listeners because, quote, it best represents the most significant segments of the economy. Under this view, more information, always better for listeners. In contrast, the dissent viewed corporations' political speech as offering little benefit and greater danger to voters. Quote, in the context of election to public office, the distinction between corporate and human speakers is significant. Although they make enormous contributions to our society, corporations are not actually members of it. They cannot vote or run for office. Because they may be managed and controlled by non-residents, their interests may conflict with the interests of eligible voters. So we can see on this first holding the justices' disagreement as to what's best for listeners. Unfettered corporate speech, political speech, is it helpful to listeners or is it potentially damaging? Now, it turns out that these differing assessments about what's best for listeners, more specifically about whether and when campaign speech is helpful to listeners or not, turns in part on how we think listeners actually process political information. In the area of public discourse, like political speech, campaign speech, First Amendment law often assumes what's called the rational actor model. In other words, like listeners carefully gather and listen to all the available information, and then they make rational decisions based on that information. So under this model, if this is how you think listeners make decisions, more speech is always better for listeners. because more speech is then available to inform their decisions about democracy and other matters. Skeptics, on the other hand, point to the many instances in which individuals don't act rationally, as defined by these models, and instances where it may be actually rational for listeners to rely on cognitive shortcuts for their decision-making. And these skeptics are unconvinced that more speech inevitably helps listeners. Here's an illustration of that skeptical view from Justice Stevens' dissent. If individuals in our society had infinite free time to listen to and contemplate every last bit of speech uttered by anyone anywhere, and if broadcast advertisements had no special ability to influence elections apart from the merits of their arguments, and if legislators always operated with nothing left than perfect virtue, then the majority's premise would be sound. So in this, the more famous of the holdings in Citizens United, the majority in dissent agreed to focus on listeners, but they disagreed about what's best for listeners. Now, next, I'll turn to the less famous part of the decision that involved a challenge to a different part of the law that required campaign speakers and campaign contributors to disclose their identities. If you watch TV and if you see campaign advertisements on TV during the election season, you know that at the end of the commercial, they say something like, "I'm Helen Norton and I authorized this ad," or "paid for by the committee to elect Helen Norton." Federal law requires campaign ads on radio or TV to disclose their source, who made and paid for the ad. And federal law also requires contributors to political campaigns to disclose their identity. Now, the challengers were campaign speakers who didn't want to disclose their identities. They were campaign advertisers and contributors who wanted to buy campaign ads or make financial contributions to candidates, but did not want to reveal their identity publicly. And these advertisers and these donors argued that disclosure requirements violated their First Amendment rights as speakers to decide what to say and to decide what not to say. Here, an 8-1 court upheld that part of the law in the less well-known portion of the Citizens United decision. There, the court, again, chose listeners' interests, but were less divided about what was good for listeners. 8 of the justices believed that information about who's talking to you, especially in the political context, information about who's talking to you is always good for listeners. The idea is that listeners, voters, often rely on a message's source to evaluate its quality and its credibility. In other words, under this view, the more information about a message's source, the better for listeners. Here's another example of a listener-centered approach to campaign speech. In a case called Burson versus Freeman, a divided court upheld a town's ban on the distribution of campaign literature within 100 feet of polling places. And if you vote in person, in Colorado, lots of our voting is by mail, but if you vote in person and you walk up to the polling place and you see that there are people standing around handing out literature, and then all of a sudden they stop, it's because you've gotten to within 100 feet of the polling place, and those restrictions have been upheld by the Supreme Court. And here the idea is that speakers wanted to speak to listeners, but some, if not many, listeners didn't want to be spoken to as they entered the polling place. And the case detailed a long history of candidates and parties' efforts to harass and coerce voters' choices as they prepared to cast their ballots. So the court upheld the law, upheld the restriction to protect voters, listeners, from coercion or interference as they approached the ballot. So occasionally, even with respect to political speech, public discourse, the court has recognized that listeners' First Amendment interests sometimes justify regulating speakers. But as a general matter, listener-centered approaches are relatively rare in public discourse settings compared to commercial settings that I'm about to talk about. These are a couple of other people's ideas that I'm sympathetic to. From a listener-centered point of view, interpreting the First Amendment to permit the enactment of legislation that requires online campaign speakers. Federal law currently just regulates campaign speakers on radio or TV to identify themselves. This would just be an extension of current law rather than new law. And another possibility is to interpret the First Amendment to permit legislation that requires the users of deepfake technology to make clear that this message has been doctored, and to identify the content's actual source. Now, switching gears, let's turn next to a very different environment, commercial actors' speech to consumers. And by commercial actors, I mean manufacturers, I mean sellers of goods and services when they're advertising to the public, or they're otherwise explaining their products' qualities, or they're explaining the terms of the commercial transaction. In the commercial settings, where commercial actors possess much more information about their own goods and services than do consumers, the court has taken a listener-centered view. It permits government to restrict speech that frustrates consumers' interests while protecting commercial speech that serves consumers' interests as listeners. So what does that mean? First, the court understands the First Amendment to permit the government to prohibit, to restrict commercial speech that is false, that is misleading, or that's related to illegal activity. For example, advertisements for illegal drugs would be considered unprotected commercial speech, as well as any false or misleading commercial speech. And the court treats this commercial speech, false or misleading speech, as entirely unprotected by the First Amendment because it hurts listeners. It's not good for listeners to have inaccurate information when they're making consumer decisions. It frustrates their First Amendment interest to have make informed decisions. Now, relatedly, the court has held that the First Amendment permits the government to require commercial speakers to make certain truthful disclosures about their products and services. And a classic example is Congress's requirement that tobacco manufacturers disclose the Surgeon General's warning on all of their packages and advertisements. Here's another example. I don't know if you can read this, but this is a law firm that is offering to take contingent fee cases. And they say that no legal fees are owed by our clients if there's no recovery. But many, maybe most non-lawyers, are unlikely to know the difference between legal fees that compensate an attorney for her time and legal costs, like filing fees and the costs of expert witnesses and other costs that can really add up. So to protect those customers, those clients, the court has held that the First Amendment permits the government to require attorneys with ads like this to disclose, to include additional language that discloses the fact that the clients remain responsible for litigation costs, which can be considerable, even if they're not responsible for attorney's fees. Now, on the other hand, the court generally protects accurate commercial speech about lawful, legal activities, because that expression is usually of great value to consumers' decision-making. And for this reason, the court has struck down, on First Amendment grounds, laws that prohibit sellers from publishing accurate information about legal products or services, information like the price of prescription drugs or the alcohol strength of beer. To give you a little background, legislatures sometimes passed laws that were designed, the intent of the laws was to keep information about legal products, certain legal information about legal products away from listeners because they worried that listeners would make legal decisions, but bad decisions. For example, they might worry that allowing advertisement about the alcohol strength of beer, even though it was legal to buy that beer, that would encourage listeners, consumers to buy beer that was higher in alcohol, precisely because the beer was higher in alcohol. And the legislature thought that was a bad decision, so sought to discourage it by regulating the information available to consumers. But the court found those laws paternalistic, interfering with consumers' interests as listeners to make informed decisions among legal activities. So a famous example, the court struck down Virginia's law that forbade pharmacists from advertising their prescription drug prices. And that the idea ostensibly behind the law was a concern that advertising prices would lead to a race to the bottom, where pharmacies would cut costs by providing lower quality professional services. But Virginia's law harmed consumers. It prevented them from comparison shopping in a market where there were considerable differences in prices. Some pharmacies at the time were selling the same drug at six times the price of other pharmacies, right? These are drugs that folks often relied on to live. And under Virginia's law, consumers couldn't figure that out because pharmacies were barred from advertising the prices unless they literally physically went door to door to look at the prices on the shelf. Now, relatedly, I have argued that courts should also treat manipulative commercial speech as unprotected, where commercial actors embed dark patterns in online interfaces that involve hidden efforts to target and exploit listeners, consumers' cognitive or emotional vulnerabilities. And examples include platforms that monitor users' keyboarding to see when you slow down or make more mistakes so they can figure out when the consumer is tired or otherwise impaired in their decision-making and target their advertising accordingly to take care of that, to take advantage of that vulnerability. Other famous examples include platforms where teenagers' social media posts show that they're sad or lonely, and advertisers target them with advertisements to buy things that they wouldn't normally buy. So I've proposed that we refine and extend current commercial speech doctrine to add manipulative commercial speech of this type to the false or misleading commercial speech that's already unprotected by the First Amendment. All right, switching gears very dramatically. Let's move from past to present and future. I want to turn to a case that's currently before the Supreme Court called Counterman versus Colorado. And this case deals with the definition of, quote, true threats that are entirely unprotected by the First Amendment. Here's a little bit of background. The court has long held that a few categories of speech, or the default rule is that speech is protected by the First Amendment, but the court has long held, well, there's a few categories of speech that are unprotected by the First Amendment. And it's identified these categories to include threats, fighting words, child pornography, obscenity, incitement to illegal action. Threats in particular have long been unprotected by the First Amendment because the harm they cause their recipients. They cause their recipients to fear for their physical safety. That fear causes terror and trauma. That includes physical and physiological harm, psychological harm, and it disrupts victims' lives in a variety of ways. Folks who fear for their physical safety behave differently. They speak differently. Now, while the court has long held that true threats are unprotected by the First Amendment, the court has never specifically defined what is a true threat. And it turns out that lower courts have split over this question. More specifically, lower courts have disagreed about whether to define unprotected true threats from the speaker's perspective or instead from the listener's perspective. Now, some courts take a speaker-centered approach, and they take the position that unprotected true threats are only those statements that a speaker makes with the intent to make their target fear for their physical safety, or make those statements with the knowledge that the statement will, in fact, make the victim fear for their physical safety. So under this approach, it requires the prosecution or the victim to prove the speaker's mental state, what was in the speaker's head when they made the statement, which can be a challenge. And the standard deliberately chooses to make it harder to prove something to be a true threat. Advocates of this perspective argue that it's necessary to make it hard to prove a true threat to avoid chilling valuable speech. In other words, the concern here is that otherwise speakers will silence themselves if they're worried about suffering legal consequences for their forceful or off-the-cuff speech. And this perspective also reflects the view that it might be unfair to punish speakers for harmful consequences that they didn't intend or they didn't recognize. In contrast, other courts, like Colorado's, focus on the listener's perspective. And they identify unprotected true threats as those statements that would make a reasonable listener, considering all of the context and all of the surrounding circumstances, fear for their physical safety. So this perspective focuses on the harms that threats pose to the listeners regardless of the defendant's mental state, harms that the listener experiences regardless of what's in the defendant's head. And again, these can be fear, emotional distress, terror, and trauma, and they can be material harms, as the evidence shows that recipients of threats miss work. They change or quit jobs. They might decline to work late. They might decline to go out at night or alone. Harms, again, that occur regardless of the speaker's mental state. And the targets of threats also experience First Amendment harms, as those who reasonably fear for their physical safety often speak less. They often retreat from online speech. They often withdraw from public life. In the case before the Supreme Court, for example, the target was a professional musician who stopped performing in public because the defendant's statements made her fear that she was no longer safe when she did so. Now, in the interest of full disclosure, I note that I'm involved as counsel in this case, as Jeremy signaled. I serve in a part-time capacity as counsel to the state attorney general. So I'm on the team that's defending Colorado's listener-centered approach here. But for whatever it's worth, I thought a listener-centered approach was the way to go before I got involved in this particular case. Now, threats are ancient problems in many ways. And I'll close by flagging the most contemporary of problems, those involving robotic or AI speech. Now, for sure, robotic speech can offer great value to human listeners. But of course, there's a complicated and sometimes dark side to robotic speech. And as we continue to wrestle with these challenges going forward, in my view, we can and we should understand the First Amendment to protect robotic speech when it's valuable to listeners, while permitting the government to regulate robotic speech to protect listeners, sometimes as is necessary to protect listeners from coercion or deception. So in short, I think we can make sure that the First Amendment retains a human focus when we attend to both the value and the dangers of robotic speech to human listeners. Here, the source of the speech is not so important as its effect on listeners. Now, for sure, hard questions are going to remain in determining when and how to regulate robotic speech. And we're going to be grappling with these questions for years to come. Criminal law and tort law are going to have to grapple with the same questions, and First Amendment law will have to do so as well. I'll close with just one specific doctrinal proposal. I think this is low-hanging fruit. It's taking an easy question now and putting off the hard questions until later. I think we should understand the First Amendment to permit the government to require the truthful disclosure of expressions robotic origin. In other words, I think listeners have a First Amendment interest in knowing who they're talking to, and that includes a First Amendment interest in knowing that they're talking to a robot. In other words, the more information a listener has about the source of the speech, the better for listeners. So I'll wrap things up. My objective today, again, has been to explain that hard First Amendment problems are sometimes hard because they require us to choose between speakers and listeners. We usually think of the First Amendment as protecting the lonely speaker of conscience, and that is very important, to be sure. But it's also important to recognize that the First Amendment is also just as much about protecting listeners' First Amendment interests. So again, my goal is that we identify principled ways for resolving the hard First Amendment problems that arise when speakers and listeners' interests conflict. And I focused on one such approach, that when we're in environments of asymmetry of information or power between speakers and listeners, that we should advantage the listeners, we should intervene to protect them from coercion or deception. But I'm very interested in listening to your view, and I look forward to continuing the discussion.
Okay. So we have plenty of time for questions. At some point, we'll cut off the questions because we also have food waiting for you. But I'm going to let Professor Norton call on people. If you would introduce yourself, that would be really nice because we're a community, but we don't all know each other. So please.
In the back.
I'm Arthur Francois. I am a professor emeritus at the law school, which means I no longer teach or get paid for doing the same. This is not the crux of your talk, but it was an important part of it, I thought. You discussed manipulative speech. So if one wants to identify manipulative speech, that depends on one's level of cynicism. But I'm guessing that you don't determine whether speech is manipulative by looking at the intention of the speaker. Again, depending on how cynical one is, almost all of our speech is intended to be manipulative. So do you always look for exogenous stuff, as was the case in your examples? Somebody is tracing the keyboard, they see that you're sort of falling asleep, and they take advantage of you at that time. They know that this young person is depressed, and therefore they sell them a product online with that in mind. So just looking for other markers of identifying manipulative.
What a terrific question. Thank you for that. So in thinking about manipulative speech, I've definitely been influenced by ethicists who have thought hard about what manipulation means. And in particular, the work of three ethicists, Ressler, Susser, and Nissenbaum, where they define manipulation as having three components: hidden efforts to target folks' vulnerabilities, cognitive or emotional, and then to exploit those vulnerabilities. So it has to be hidden, sneaky. If it's not sneaky, it's not manipulative. And it has to be targeting vulnerabilities and then doing something to exploit them. So the examples that I gave you fit that pattern. But it's a very good question about, all right, if folks regularly just take me seriously about this, and some do and some don't, how would you actually identify manipulative speech that I think should be unprotected by the First Amendment? How do we know for sure if it's hidden and it targets and it exploits vulnerabilities? Well, there's a couple of possibilities. One is if it has features that show those three things. And again, I deliberately chose those two examples. Users whose keyboarding shows that they're vulnerable, and it's hidden. The fact that their keyboarding is being monitored is not obvious to them. And the advertisements exploit their vulnerabilities. And teenagers whose posts show that they're sad or lonely, again, it's hidden. And the advertising targets their vulnerabilities. The idea that people buy different things at higher prices when they're sad and lonely, certain things, not everything, when they're sad and lonely than otherwise. So that's one way to do it. If you see those three components, hidden, targeting, and exploiting vulnerabilities. Another way is to measure the effect. And there are folks who you can do A/B testing. I mean, the fact these dark patterns are not by accident. The folks who develop them have tested them, and they know that they work. They know that they change the buying behavior of folks who are subjected to them. So if the producers of the dark patterns can do that testing, and the testing shows that sometimes a manipulative interface increases the chances by 2, 3, or 4 times that the user is going to buy something compared to a non-manipulative interface. If the manufacturers of them, the creators of them, can test them for those manipulative results, so too can regulators. So when regulators test an interface and they find that is so successful at changing a consumer's behavior from the baseline, that might be another way to measure manipulation by its effects, not just its features. Thank you for the question. Yeah.
I'm Valerie Couch, Dr. Norton. I'm Dean Emeritus. Okay, I think there's a lot of emeritus in Mr. Borney. Wondering about your analysis of the university setting, balancing speakers and listeners' interests. What principles would help you do that?
What a good question that is. So context matters for sure. I think and hope that what we are doing right now is public discourse where speakers and listeners are in a position of equality. It gets a little bit different when I enter the classroom, right? Where I do have a type of power over my students, right? It's not unlimited, but it's a type of power. And they're, students, hopefully when they disagree with me, they can talk back, hopefully if we're both engaged in norms of civility, right? Civility and listening, but they might not feel so comfortable doing that. And so that's a situation where I think the speaker, I don't know if regulation is the way to do it, but as a speaker, that I think you should try to be aware of your power and to try to find ways to give the listener room or comfort to talk back. But but the bottom line is, I want to take away from it is not every university setting is the same. I think that some settings are much clearer public discourse environments of equality, and I think other settings it's not so clear to me that it's an environment of equality.
I have a question to go off of that. Sorry, everyone, I'm Brielle. My name's Clara, and I was mostly interested in the intersection of like how you can kind of promote more discourse, like what we're doing right now, where there are definitely listeners' rights, but also speakers' rights, and how can you prevent manipulative speech from influencing listeners, and how can they kind of be more involved and also like, I don't know, promote more discourse, because I think speaking more and having a civilized discussion will promote democracy, like what you started out with this lecture. And I'm seeing a lot of decline because of the use of social media and things like that.
And do you, thank you for that question. And I will answer it, but first, sometimes when somebody asks a question, they have actually a specific example in their mind, and it's helpful for me to hear it if you have one that you wanted. That it's okay. It's okay.
Very broad.
Yeah. So, let's go to the public discourse, right? Let's assume this is public. The idea behind public discourse is that when we do it right, it actually is an environment of equality between speakers and listeners, right? And I'm talking, but I don't have any power over you. And if you don't like what I'm saying, you could leave, or you could raise your hand and say, I disagree, and this is why. And that's the gold standard for public discourse, which is not all speech, right? We have definitely different rules in the employment setting and the classroom and commercial setting, et cetera. But that's public discourse. But I understand your question to be, well, that's the aspiration. We're not there. That's not what we have. Yeah. Well, I don't know that government regulation is the solution to that. I think a solution is norms of behavior, right? How we behave ourselves and how we expect other folks to behave, and what we do when folks violate those norms of behavior. And social media does not always encourage norms of civility and listening hard and thinking hard before you speak, but that's what we're aspiring to. So my own view is that each of us as individuals, when we're engaged in public discourse, that we should commit, to a certain personal ethical code. I'm not going to call anybody names. I'm not going to raise my voice. I'm going to try very hard to be truthful. And if I'm engaged in a conversation where that's not happening, I can try. My first choice is counter speech, to explain this is why I'm unhappy with the choices that you're making. And my second choice is to spend my time elsewhere. Life is too short, I think, to be spending a lot of time trying to get somebody to listen when they don't want to listen. So I would prefer to exit to other conversations. I don't know if that's responsive to your question.
But I just also wanted to piggyback off of that with the Restrict Act. That's in Congress right now. It's the Restricting the Emergence of Security Threats that Risk Information and Communications Technology Act. I don't know if you've had a chance to read up on that and what your thoughts are on that.
I'm not familiar with it. I'm sorry about that.
I'm curious along that same line, because we see this every so often in a university setting where professor is presenting information, hopefully for discussion. Student or two take offense but do not engage in the conversation, but leave and then report them. And then the next thing we know, the professor's been fired or censured or something because of that. And so it's like, to me, that's not fair to the professor, who I hope is helping us expand our minds, to have a student not engaged, but then go and report.
So thank you for the question. A lot depends on the details. I mean, I think there are situations where there are innocent speakers, and I think there are situations where there are innocent listeners, and I think there are situations where everybody behaved badly. So you've probably heard this joke that before you go to law school, if somebody asks you a hard question, you have a 3-word answer, which is, I don't know. And after you go to law school, if somebody asks you a hard question, you have a 3-word answer, and it's, well, it depends. And that's why I felt listening to your question, is that I would want to hear a lot more about what happened before I made a judgment about who was in the right and who was in the wrong.
Well, there was a study, I can't cite it right off, but I had listened to a speaker talk about freedom of speech on campuses, and it was very interesting. The ones, the big Ivy League had released, it's very restricted, is the way they measured it and going to read the study. Whereas in some of the others, it was much more open. And I thought, well, how do you get to the open? Because to me, that's the whole thing, is that it's that freedom of speech and back and forth that help you learn and expand your mind and all. But then some of our universities are being very restrictive on freedom of speech.
Yeah, my name's Seth Carlett. I'm actually a software engineer. My fiance and the 3L here, so we'll take that in mind. So I don't know if you're aware of like the Twitter files and stuff that's going on with Twitter. Kind of her point about social media earlier. Twitter, there was a bill that was previously passed in the early 2000s that moderated
that gave companies like Twitter and Facebook the ability to moderate their own comment section, essentially. So effectively, you post on Twitter, Twitter has the right to silence you, deplatform you, whatever. We've seen a bunch of this in recent past. Been following Matt Taibbi and Michael Schellenberg Twitter files. They've talked about government influence within Twitter, where many governments, all political sides, reached out to Twitter high up and had people tweets taken down, people deplatformed, silenced without their knowing. So Twitter is effectively the moderator in free speech here. I was kind of curious on your thoughts on that, as where that stands as far as Twitter being allowed to do that, rather than not being able to, the individual not being able to be protected.
Thank you for that question. So first, I'll give a First Amendment. I'll give several layers of First Amendment answers. So first, just to recall that the Constitution, including the First Amendment, is all about what the government can or can't do, right? The Constitution, with the exception of the 13th Amendment, says nobody, governmental or non-governmental, can engage in slavery. That is the only part of the contemporary Constitution that speaks to anybody other than government actors. We used to have prohibition, which also told everybody, governmental or non-governmental, what they could do about making, but that's no longer. The rest of the Constitution, including the First Amendment, is a directive to the government protecting speech from unjustified interference by the government. So a private actor like Twitter, or like your employer, if you work for a non-governmental employer, a private actor can never violate the First Amendment. The Constitution doesn't speak to what private actors do. It speaks to what their governments do. So Twitter can't violate the First Amendment. Now, as a matter of policy, you may agree or disagree with what Twitter does. Twitter obviously has been undergoing a lot of change recently. But if you look at the arc of Twitter's content moderation policies, they started out doing very, very little content moderation. And then over time, they started to do more content moderation, in part because of many listeners' demands saying, I don't want to see pornography when I'm on social media. I don't want to see hate speech. I don't want to see threats or bullying. This could be a situation where listeners disagree, that some listeners want to see the speech and some listeners do not want to see the speech. And private platforms, they can't violate the Constitution when they're making different choices about what to moderate or not. And they might understand themselves as creating different communities, and that listeners, users, can sort them out by communities depending on what speech that community allows or doesn't allow. So it's not Twitter's choice about content moderation, which again has changed over time and continues to change over time. That choice itself doesn't trigger First Amendment inquiry. Now, when the government, and of course, this is going to be headed towards the Supreme Court, I'm guessing, next year, when the government, and we've seen a number of states do this, Texas and Florida in some ways, and New York and California in other ways, when the government regulates platforms and tries to tell them what decisions they can make about content moderation, that's the government regulating. So we have a First Amendment question for sure. The government is now in the mix. And the big unanswered question is, but is it a First Amendment violation? Now, so far, that dispute has been couched as a conflict between speakers, that the platforms describe themselves as speakers. We are editors. We are curators. We're like the folks who make decisions about what news and what opinions to print in the newspaper. And this is our speech product. We decide, and you either like it or you're not. And if you don't like it, you can join a different community. Whereas folks who've been deplatformed are speakers too. And they don't want to be deplatformed. They want all of the audiences that the different platforms be in. So far it's been described as a clash between speakers' interests. I think we should start to think about listeners' interests as well. I don't have the prescription now, but I don't think it's just about speakers. I think it's about listeners. And I don't know that this makes it easier. I think it makes it more complicated, because lots of listeners do not want to see what they believe to be hate speech or pornography or disinformation in their platform of choice. And other listeners want to see their favorite speaker on their platform of choice. So this is a situation where listeners' interests maybe complicate the problem, but I think they're an important part of the problem. Thank you for the question.
So, I see stuff. So you have the energy for one or two more questions?
Absolutely, as long as you want. Hi.
May I ask you a question about attorney statements to the media and the context of litigation? It's more of a defamation question than what you've been talking about. But But we have a recent Texas Supreme Court case that overturned decades of attorney immunity for comments made in connection with cases that they're litigating. And I followed this case very closely because I'm one of the named defendants. And that's particularly sort of to give you an example of what happened, I sent the plaintiff a 60-day notice of intent to sue for violations of the Endangered Species Act in the Landry's, Houston, downtown Aquarium. They responded to my letter with a defamation lawsuit for providing a copy of the letter to the media and then publishing via my private Twitter account coverage of the letter and the potential lawsuit, along with some of the statements that I made in connection with that. So I'm just wondering where you would weigh that, the advocacy, particularly in the context of like social justice advocacy by attorneys. Mm-hmm. How do we weigh the advocacy in a public forum, discussions of cases with the media that are newsworthy? How do we, where would you balance the listener versus speaker interest there?
Yeah, thank you for that. Just to give me a little bit more background, was the other side's allegation that this was defamatory or that violated professional ethical responsibility rules? Yeah.
And so just for the procedural history, I prevailed on an anti-SLAPP motion to dismiss, which was affirmed on appeal. And then Landry's appealed to the Texas Supreme Court. The Texas Supreme Court declined review. And then there was an election. There was a new composition of judges on the Texas Supreme Court. They filed a motion for reconsideration. The Texas Supreme Court accepted the case and then overturned attorney immunity. So, which is decades of attorney immunity. So the case was very watched by all types of lawyers across the state. I don't know if this is a growing trend in declining that type of immunity or the way that we discuss important cases in media interviews. I've not looked at other states to compare, but and long story short, after 5 years of litigation, we settled with a take nothing settlement. So both sides walked away.
Thank you. So that strikes me as complicated in ways that I don't feel super competent to weigh in on. So I'm going to talk about defamation more generally, and I realize that might not be satisfying to the specifics of your case, but I'm going to do the best that I can. Just sort of stepping back to think about the First Amendment and defamation law. The court in the famous case New York Times versus Sullivan basically said when the defamation defendant is a public official who is alleging defamation, that somebody, when the defamation plaintiff is a public official and they're alleging that someone critical of their efforts engaged in false and defamatory speech, the Supreme Court has chosen a rule that's deliberately tough on that public official plaintiff, because the idea is that criticizing the government is key to a healthy democracy. So that makes it hard, not impossible, but hard for a public official plaintiff to prevail in a defamation suit. And that's to protect both speakers, political dissenters, people who are critical of the government, and also to protect listeners who have First Amendment interests in hearing criticism of the government. Whereas in contrast, the court has chosen a considerably more plaintiff-friendly defamation rule when the plaintiff is a private figure. And the idea here is that both speakers criticizing private figures in false and defamatory ways have that speech is of less value to the public, and listeners have less First Amendment democracy interests in hearing that speech. So that's a way that defamation law more generally considers speakers and listeners' interests to be at threat or at greater threat in defamation cases criticizing public officials as to others. Now, I don't know anything about the Texas case and the trend, so that's the background, and so I don't have texture. And I think that is specific or satisfying to you. And I'm sorry about that.
All right, so I'd
There's-
like to thank, there's one more question. Is there?
Yes.
Yes. Mr. Shea. Professor Shea, Professor Tim Shea, I'm not Emirates. Just joined the faculty, but thank you for your very riveting presentation, especially your last slide. I found that fascinating. And maybe a question that will go towards maybe the core theme of your presentation. I was wondering earlier, a couple months ago, Professor Blitz and Talman and I had a Section 230 panel presentation, and we were talking about how maybe in one of the cases involving YouTube, I think it's Google versus Gonzalez, where that algorithm that it heavily encourages you to click on a next video that would be interesting would be potentially manipulative in that it's basically sucking you into the cycle. And that might be, but there's debate on whether or not that's speech or something that's just a byproduct of the actual website that if you treat it like a utility, for example. And, there's arguments both ways. And you might have instances too where AI or some machine program is serving as a listener or sensor for maybe pornography or hate speech. And then most recently, you have maybe programs such as ChatGPT, which almost serves as both a listener and a speaker, in that you're inputting information and then it's almost simulating a real life conversation with a human being. And these AI art generating programs where you feed it input and it generates potentially commercial speech, but just artworks that infringe copyright laws and things like that. And so I found it very interesting when you mentioned at the very end where you should have the right to know if you're talking to a robot or not. And now at this sort of like very accelerated breakneck pace in which AI is evolving, you feel that one day AI entities or machine programs will be treated like speakers and listeners, very much like what you're talking about for human being speakers and listeners in your presentation, or will it be one day where AI will become so close to that the line will become so increasingly blurred, it'll just be impossible to tell if you're talking to a robot or not.
That's a very interesting question. Right. I mean, currently we can figure that line, and currently we can still always trace a robot or AI speech to a human being. And there are folks who wonder if there's going to be a period of time where we can't, that we think that this AI is sufficiently autonomous. It is no longer tethered or directed in any way by a human being. And there are technologists who think that will never ever happen, and there are technologists who think that it might. So I understand. So this is something of a thought experiment. It is very possible that technology may, when I say First Amendment law needs to maintain a human focus by privileging its human listeners, it is possible that it will be harder to say who or what is truly human and who or what is truly something else. This is a big old punt, but I don't think that's going to happen while I'm alive. So I'm not going to. I'm going to worry about the low-hanging fruit for now, but I very much appreciate it as a worthy thought experiment.
Okay, so I'd like to thank Professor Norton for a very stimulating hour. I'd like to thank the Quinlan family for making it possible, and I'd like to thank Social Norms for keeping you all from rushing the stage right now. But there will be a reception. As you can see, Professor Norton is very amenable to questions, so please take the opportunity to engage.
Thank you.